Hello, I'm Dr. Terry Susan Fine, Content Specialist for the Florida Joint Center for Citizenship, which is part of the School of Politics, Security, and International Affairs at the University of Central Florida in Orlando. Welcome to our Middle School Civics Highlight Series. Today we focused on benchmark CG 3.11, Landmark U.S. Supreme Court Cases. In Part 3, we focus on recognizing constitutional principles and individual rights in relevant U.S. Supreme Court decisions and evaluating the impact of each case on society. In Benchmark Clarification 3, students will evaluate the impact of each case on society, while in Benchmark Clarification 4, students will recognize constitutional principles and individual rights in relevant Supreme Court decisions. We ask, what is the impact of each case, and what are the constitutional principles and individual rights in relevant Supreme Court decisions? First, we focus on Marbury v. Madison and Dred Scott v. Sandford. Marbury v. Madison achieved a significant impact within the context of the constitutional principle of checks and balances. In this case, the U.S. Supreme Court decided that it had the power to rule on the constitutionality of national and state laws and executive actions. This means that the U.S. Supreme Court has the power to overrule or find unconstitutional government actions executed by the legislative or executive branch. This is a significant impact because the U.S. Supreme Court gave itself the power to determine that an action by an elected branch of government was or was not constitutional. This concept of judicial review is found nowhere in the U.S. Constitution. However, the Chief Justice of the U.S. Supreme Court at the time, as well as the other justices sitting on the court, they decided that within a checks and balances system, the only place where the constitutionality of different laws and executive actions could be judged would only be within the judiciary branch. And we see good reason for this. For example, laws are passed by Congress and signed by the President. So how could either the President or the Congress make a decision about their own efforts? Who was not involved in the lawmaking process? Only the courts. The courts are also holding life terms, and consequently, they don't need to be concerned about political forces that may influence how they might otherwise behave. And so, within a checks and balances system, the best and fairest place for judicial review to take hold for the constitutionality of legislative and executive actions to be judged must be from the judiciary branch. Looking at Dred Scott v. Sandford, in this particular case, the U.S. Supreme Court determined that persons, whether slave or free, are not entitled to U.S. citizenship because it was not the intention of the framers of the Constitution that persons who came to this country as slaves be classified as citizens. Therefore, the descendants of those persons who came to this country as slaves could also not be classified as citizens. In this particular case, Dred Scott was seeking his freedom, and consequently, it was a Fifth Amendment case in two different ways. One, how could the government take property from a private individual? Slaves were property at the time. How could the government take property from an individual? That would be a due process issue. And it's also a takings issue. The Fifth Amendment also includes the takings clause, which says that the government cannot take a person's property without providing them with appropriate compensation. So both the due process clause and the takings clause were appropriate in analyzing and looking at the Supreme Court's reasoning in Dred Scott v. Sandford. What about Plessy v. Ferguson? In Plessy versus Ferguson, the U.S. Supreme Court decided that the 14th Amendment Equal Protection Clause was not violated when a state law mandated that when it came to public transportation, that there be separate spaces for blacks and whites. And the Supreme Court was asked to evaluate the 14th Amendment Equal Protection Clause and to look at it through the lens of, are people equal and are they being treated equally if they are separated? And the Supreme Court said yes, that separate but equal does not mean unconstitutional. And so the constitutional principle here is the 14th Amendment. But the 14th Amendment Equal Protection Clause also applied in Brown versus Board of Education when the U.S. Supreme Court struck down the concept of separate but equal narrowly, only focusing on children attending public schools. Now, children attending public schools comes from a state mandate that children must be educated, and they must be educated in public schools unless they are provided with alternatives to public school. So by the state requiring that there be separate facilities, the Supreme Court decided that these facilities were not equal. However, the decision only applies to children in public schools. So Brown versus Board of Education was also a 14th Amendment equal protection case. Next, we look at Gideon versus Wainwright. Gideon versus Wainwright focused on the constitutional principles of the Sixth Amendment, which focused on the federal protection of providing assistance of counsel for those who could not afford it. That the Sixth Amendment guarantees to every person who is being prosecuted the assistance of counsel. And in Gideon's case, he could not afford assistance of counsel, and he said that he was entitled then for the government to provide him with assistance of counsel. And what the judge said in his original case, where he was being prosecuted for committing a robbery and a break-in, was that the nature of his crime was a state crime, and that the Sixth Amendment only would apply to federal crimes because the U.S. Bill of Rights focuses on the federal government. Even the first word of the U.S. Bill of Rights is Congress. That's the national legislature. However, what the Supreme Court decided through the lens of the 14th Amendment Due Process Clause, which says that no state can deny any person their protection of due process, the Supreme Court took the Sixth Amendment and applied it then to the states, thus contradicting the first judge's reasoning who told Clarence Earl Gideon that he was not entitled to an attorney because he was accused of violating a state law. So here we see, in essence, the spreading of the Sixth Amendment, of a right in the Bill of Rights, to the states. Then we look at Miranda versus Arizona. In Miranda versus Arizona, this decision strengthened the rights of the accused by guaranteeing that persons accused of crimes be notified of their Fifth Amendment rights that protect them from self-incrimination. As well, persons notified of their Fifth Amendment rights protecting them from self-incrimination must confirm that they understand those rights. So the Fifth Amendment, which is part of the Federal Bill of Rights, was then extended to the states through the 14th Amendment Due Process Clause. We now focus our attention on In re Gault in United States versus Nixon. In re Gault focused on whether or not a juvenile, a person under the age of 18, must be provided with the same constitutional guarantees as adults accused of crimes, such as the right to counsel. And the U.S. Supreme Court decided that indeed, regardless of a person's age, that they were entitled to the same privileges and liberties as a person who was an adult in the context of criminal procedure and due process. So the constitutional principles focused on the right to an attorney from the Sixth Amendment and the 14th Amendment Due Process Clause, which then extended the Sixth Amendment to state treatment and state crimes. In United States versus Nixon, we see a decision focusing on legal equality, on the principle that no one is above the law, including the President of the United States. The U.S. Supreme Court determined that the President was not protected by executive privilege that would otherwise keep evidence of a crime from public view. We now focus our attention on the last case of this group, Hazelwood versus Kuhlmeier. In this 1988 case, the U.S. Supreme Court focused on the First Amendment right to free speech and determined that in a school setting, that student speech may be limited by K-12 school administrators. What this means is that student speech must be reasonably connected to legitimate pedagogical concerns or teaching-related concerns in order for students to be able to have free speech. So consequently, the U.S. Supreme Court said it's in this setting that students may be limited as to what they can produce, that's the speech part, and then publish and distribute, that's the press part, in a student newspaper. So even though this particular case does deal with the publication of a student newspaper, the issue at hand is the text that was intended to be published in that newspaper, and consequently this is a free speech case. Thank you for joining me for Middle School Civics Highlights. Do you still have questions? If so, please contact us using the information that appears on the screen. Till next time, I'm Dr. Terry Susan Fine. Thank you for joining me.